Are we going to be able to go start here in a minute or so?
Yes, I'm setting up the live stream right now. So I just want to make sure that it's actually up and running here really quickly. So I appreciate everybody's patience.
Okay, just let me know when.
It looks like it is live streaming. So looks like you have 1 minute to your official meeting time. So we'll be ready to go right on time, Chairman Thorvald.
Thank you. It is 1:30 on October 24th, 2025, and this meeting, working session of the Arizona Oil and Gas Conservation Commission is called to order. This is Chairman Thorwald, and I'm here. Commissioner Nations, are you here? No. Commissioner Firerobin, are you here? Commissioner Firerobin, did we lose him?
His mic's off.
Your mic is off. I'll come back to him. Commissioner Conway, are you here?
His is off also.
I
am here.
Okay. Commissioner Ballard, are you here?
Here, sir.
Commissioner Firerobin?
Yeah, here.
Great. Is there any conflicts of interest? We have a quorum. Is there somebody representing the AG's office with us today?
Taylor Parmenter, Assistant Attorney General.
Thank you for coming. Is there someone here from the Land Department?
David Haig, present.
Pleasure to have you, David. With no conflicts, let's move on to item 2 on the agenda, call to the public. This is a working session, and that's why we're doing the call to the public at the beginning. Is there anybody that would like to address the commission? Hearing nobody, we'll move on to discussion through item 3 on the agenda, discussion regarding possible changes to the Arizona Oil and Gas Conservation Commission regulations. I'm going to let Commissioner Ballard handle this. Commissioner Ballard.
Thank you, Chairman, Mr. Chairman. We have quite a series of attachments to go through associated with item 3, and I think we'll just allow them to guide our conversation. I really think it's within the realm of possibility that we can kind of finish the rough form for these draft regulations, and I hope it won't take too long. I know it's hard to get people to come out for a work session, and we'll try and move through them fairly efficiently. Can I see the first attachment, please?
Oh, okay. So sorry. I actually was going to let you.
No problem. Oh, I can do that. I didn't.
No, if you'd like to, it's up to you. This Commissioner Ballard.
If you can bring it up, that would be easier at this point.
Okay. Okay. So, and I am sorry, but what is the other one you need up besides agenda item 3?
Let's start off with what's in order, and then we'll get to the one where I need to see 2 at the same time.
Okay. Are you all able to see it?
I can see it.
Yep.
Okay, so the first rule that we'll be discussing today is R12-7-101, and we actually have not talked about this one as requiring changes in its original state. It's a list of 15 or so short definitions of most of the things you can think of, well and injector well. But in the course of working on the rule for hydraulic fracturing, basically, number 117, this has come up that a large part of that rule requires some new definitions, basically on what artificial stimulation is, and then they have some suggestions for high volume hydrologic stimulation. So I don't think we have to really discuss this now. There's two options. I like the changes when you have looked at the text for 117. It's kind of hard to read, but so the real biggest is just where to put this or most of this. We can add it to the list of definitions in 101, or we can keep it in the section 117. So I think we'll just defer that decision or recommendation until we get to the discussion of artificial stimulation and hydraulic fracturing. If no one objects, you will, just glancing at reading a few of the lines, you'll see when we get to that other rule that it's verbatim. It's just in a different format and cleaned up nicely. So if we can go to the next one. This, I think we've probably talked about more than anything else. I also regard this as just something we can briefly look at. Of course, the bond issue, one of the main changes was to turn it into financial assurance. And the main reason to do that was so instead of the traditional bond, we could also accept certificates of deposit. At first, I thought that might be kind of a strange thing to do, but then I realized that some of these bonds might actually be out for 20 years. If a well is successful, the bond is not relinquished until the well is plugged and abandoned. So you might as well accrue some interest. I guess I can understand the motivation for that. At any rate, so we hadn't changed. That's been changed by the AZOGCC review, and it seems okay to everybody. So the only things we really changed here was the two key issues was the amount of the bond. They recommended a fairly modest increase from the current $10,000, and I think everybody went along with by vote with a $25,000 bond. Basically because costs have so much increased, and we in Arizona don't have a oil and gas conservation fund to pay for things like abandoned procedures, orphan well type situations that might arise at some later date. So I think even though it does progressively go up with wells over 5,000 and 10,000 feet, I tried to make a sampling of all the other states with active oil and gas drilling, and really 25,000 for about a 5,000 foot well is pretty close to the average, and it's exactly what New Mexico is charging. So I think it's appropriate. The other change that I think everybody agreed with came from the commission, that all this interest that might be accruing on a certificate of deposit should go with the fate of the bond. In other words, if it's returned to the operator, as of course we really hope to do, any accrued interest would go with it back to them. But if we have to seize the bond in order to get work done that they refuse to do or are no longer in business to do, the interest will go with the bond to the commission or the certificate of deposit. Any comments on this one? I think this is the one we've talked about the most.
I personally like that. This is Chairman Thorwald. I like what we've done here. Commissioners, do you have any comments? Are you do you find this appropriate? Any changes?
This is Mike Cowie. I certainly find it appropriate.
We as I recall, we have what other states are doing in this area, and the AZOGCC recommendations on this. Do we not?
Yes, this information was compiled from the AOGC report that we got. I believe we got an updated one just last year that had a survey of the various states and the amount they charge for bonds, they charge for initial permit fees, and a couple other items as well.
I just wanted to say, when we submit these things to the governor's office and to GERC, I just want to make sure that we have backup for what we're submitting.
I still have that document. Yeah, we could easily put that together.
What now? I know previously that we put all these things out to all of the our constituents, our stakeholders in all of this, and asked them what they thought. Now, this change we have not. I suspect we should do that again and get their feedback before we submit this to the governor's office for approval. To go
Sounds
to
like a good
GERC.
idea, Mr. Chairman. But we can, as we go through, I mean, it's only a set of 7. We could just send them all, or if you want to pick and choose, I'm sure we can send them out for review.
I think it would be appropriate to send them all once we go through that. And I know I should have waited till we got done with all of these. But commissioners, do you see anything that we need to change, or is this going to be fine?
Are you talking about the entire document?
No, just this one section.
This section, okay.
This one R12-7-103 financial assurance. This section only.
I'm fine.
This is Mike Cowie. It looks very good to me.
Then do we have a motion to approve this to R12-7-103?
Well, I move we make that approval, Mr. Chairman.
Do we have a second?
Fire off
second.
second.
Okay, we have a second. A motion. All in favor say aye.
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 Aye. Any opposed? Any abstention? No, the motion carries. Let's move on to the next one then.
Okay, so this should be, let's see what is next. Spacing. Okay. So yeah, this is R12-7-107. And we have made some changes here. And I think from looking at the regulations that really the commission has given a fairly free hand with spacing. And I've made a couple recommendations that we give a little more information out in our rules as to what could happen under spacing, as opposed to just kind of leaving it at all discretion. But as far as the statutes I have looked at, it's not a big change. It's just more specificity. It's not that much of a conflict. The one thing that I've noticed more recently is that the first section here, which is definitions, it's not a problem, but a couple of the definitions are really just references to that section 101 that we were talking about a minute ago. In other words, there is already a definition of gas well. There is actually also a definition of geothermal well in a slightly different rule. And there's also a definition of oil well, which they also referred to. So it's really just an editorial issue, but whether we want to include redundant definitions or not, I suppose it doesn't really hurt anything, but they are redundant. The only probably real issue that exists is down under pool and drilling unit. And we'd already flagged drilling unit as a possibility, so I looked it up and I found pool also. So they're defined, I believe, also at section 101, and the wording is a little different. So if we want to keep the definition for pool and drilling unit here, we should just mimic exactly the words that are, particularly what words that are in statute, just to be consistent. So that's just an editorial thing. I don't know how people feel about it, if they want to cut this back or just clean it up so that it's exactly like appears in other rules and statutes. That's just a recommendation.
Commissioner Ballard, this is Chairman Thorwald. I personally, I don't know how everybody else thinks, but I think we should have one overall definitions page that defines all the definitions for all of the rules that we have, and refer to that. And that should be consistent with the statutes that we currently have out there. If there is any specific term that is defined in statute. Otherwise, I think we need to go ahead and define them. Commissioners, what do you think?
Fire Robin, I would agree with you. I think like a definition, one definition page at the start, and then you just refer back to it as needed.
Yeah,
This is Mike Conway.
only
I
issue in
certainly
following
agree.
through on that is all these definitions would be in, like I was saying, R1 12 7 101, with the exception of geothermal well, just because that kind of came in later and was defined in a kind of parallel set of statutes when and regulations when it was put in. That one is in a different section. I think it's in it's in 27 651, which is a statute. So we would just have to make some reference to a statute for that one definition, as opposed to just being in that main section with all the others.
I have this is Chairman Thorold. I have a question. In that section, this is in our rules that we have, not in the statute. So we certainly can change and put in that rule what is in that statute and say this is the definition defined by the statute.
Okay, I see that, yes. We'll add it to 101, just make sure it's the exact same language as exists elsewhere in statute.
Yeah. Commissioner Conway, you were going to say something.
Just that I agreed with that, the initial discussion. It works fine, keeping it on a single page and making certain that the definitions remain the same throughout.
Okay. We can come back to that when we get to the definitions.
Okay. Well, the second issue is a little more substantive. Like I was saying, the commission has broad authority to assign spacing for wells, but what's in the rules just kind of defines what you're going to do for a gas well and what you're going to do for an oil well. And of course, the gas well is 640 acres and the oil well is 40 acres. So there's been kind of history in the commission that if it's not going to be a 640, if there's some reason, we just kind of default to the 40, which is it's appropriate for some gas reservoirs, but that's kind of on the extreme end. There's all kinds of other spacing units we could use. There's standard spacing units of 320, 160, 80, 40, and they're all defined by API and in various other places. So I thought it was important, and you guys have seen this before, that we just introduce kind of an automatic default. Instead of trying to go all the way down to 40 spacing, 40 acre spacing, we should, for these like exploratory gas wells that are not going to target the Coconino, just allow them at their choice to apply for 160 acre spacing. It won't require any kind of a spacing exception, and it's their choice if they want to stay with a 640 and hold out some hope of having a Coconino reservoir. But in over half the basin, the Coconino is actually what you're standing on the surface. So it really doesn't have any potential. And no other reservoir in the Holbrook Basin has proven to be that good and require a full 640 acre spacing. So if they want kind of an open spacing until they actually establish a discovery in a certain reservoir, I would offer them 160 acres. That gives them quite a bit of more leeway as to where they can locate their well. And the second item under item A is really also just to kind of write down a little bit more of what's going on. Anyway, we're defining spacing for some reservoirs. We've defined it for the Coconino, which I referred to. We've also defined it for the Shinnerup, and we've defined it in one case kind of for the Mississippi and Devonian interval. And those should be available more or less for permission to drill a well on those previously determined spacing in those previously determined areas without a spacing exception. It's if someone comes to us who wants to drill a Shinnerup well in the area where the Shinnerup wells are being drilled near Holbrook, it should be automatic. We shouldn't have to have a spacing hearing for that. And I think that's fine under the rules as long as, of course, the commission approves.
Now, how does that vary from API?
Well, the definition is the same. In other words, they have a definition of 160 acre spacing is it's a quarter government section. It can, if you have an unusual bent government section or something, it can be specified by acres, but that all is under the approval of the commission. No, there's really, and some of the states, especially in the older days, used to actually, specify a whole series of possible spacing exceptions. I mean, spacing units, put in a little table as to how many acres they would have and how many feet. And so those definitions are available, and this is the standard one for 160 acres. So it is pretty much in line with that definition.
Commissioners, what are your thoughts on this?
I have a quick question on the spacing. You kind of referred to it. There are sections that are odd sized. As I read the rules, there's kind of no exception for those. But Commissioner Ballard, you kind of referred to apparently there's a process if you have an odd section, how to handle that. Is that correct? I did not catch that in reading if there is.
Yeah, you can, I mean,
Commissioner Fire, make sure you announce yourself, especially without your video on, so
okay,
it's clear for the record.
yes, Commissioner Fire, I think it would be, if nothing else, there's a section farther down in the rule that more or less states that the commission can custom design a spacing unit at the application of, an operator and our satisfaction that it's appropriate. So it's really pretty wide open. Yeah, if there's an unusual shape or something to the land that they want to form, of course, this is a matter of forming a drilling unit. The commission is at liberty to approve just about anything that's reasonable.
Commissioner Conway, your thoughts?
This looks perfectly fine to me, and it seems appropriate.
Yeah, this is Commissioner Ballard again. In fact, actually, it's in the view, Commissioner Firebrand, the section 2 down below, the majority of the yellow there, in areas either not covered by United States public land surveys. We can do what is necessary, and then it's a little bit farther down. That basically, it's basically all the way down in F, A, B, C, D, E, F, 7. Okay, I guess it's got relabeled G here in order to prevent waste. The commission may use different spacing requirements and grant greater acreage for drilling units than the specified for oil, gas, or geothermal resources under the provisions of B, C, and D. So there's a recourse if there's some unusual situation. None of our spacing units are absolutely locked in. They're just the normal. Well, this actually brings up the last issue. If there's no more discussion on that, it really was just when we do have to hold a spacing exception hearing. There's been a little confusion as to the notification, who has to be notified, and whether that the commission needs to actually have like proof, that process has taken place. This came up recently in the last spacing exception we handled, and this really just kind of consolidates that observation that it needs to be clear that they have to notify people within 1 mile of the location, and that they have to be able to, and this recommends, of course, that's done by certified mail, and that they have to provide some proof to the commission that that's been done. Usually you get a receipt with certified mail if you ask for it, and that's what was acceptable to the commission before. So just to make sure that read smoothly, these are really almost word changes, but we've eliminated a reference to the surrounding leases and substituted that phrase within 1 mile of the proposed location. And we've added the proof part to both the normal spacing exception. It already existed if in the section where a spacing was changed because the well products that's changed, went from an oil well to a gas well or something like that. So it was really the same language that existed before. We just edited it up so that in both cases, the commission receives proof that the notification process has gone through, and we can continue to address approval or not approval.
Commissioners, your thoughts on that?
This is Mike Cowie. It sounds like a very good working model to me.
I'm fine, Fire Robin.
And this is Chairman Thorwald. I'm also fine with that. Well done. Is there anything else on this particular one?
No, Mr. Chairman, this is the end of the discussion for 107 spacing.
Do I have a motion to approve this?
This is Mike Cowie. So moved.
Second. Do we have a second?
Fire Robin, second.
All in favor, say aye.
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 Aye. Any opposed? Any abstentions? The motion carries. Let's move on to the next one.
Okay.
Chairman Thorwald, this is Taylor Parmenter with the AG's office. I just wanted to clarify on the prior vote, is the vote still to move those definitions to section 101?
We we're waiting until this is Chair Thorwald. We're waiting till we get back to that sections to vote on that.
So this is Taylor
Well, I see.
Parmenter. So was the motion to approve 107 with the definitions or without the definitions?
Without the definitions.
Okay, thank you.
Go ahead.
So, good point there, Taylor. Thank you. So I guess we can move ahead. This is where we're going to start a series of 3 rules, which are very engineering oriented. They're the ones on surface casing, irregular, intermediate casing, and defective casing. And when we had the last discussion in the previous work session, I think I expressed and some of the other commissioners expressed not a lot of background in analyzing engineering specifications. So of course, the approach I took was, we have gotten these directly from AZOGCC, and they of course have lots of engineers. And in fact, the language and the rules that they were proposing to us actually turned out with some investigation to be very standard, very similar to other states which have adopted AZOGCC rules. And in particular, just for reference, I looked up Texas. Of course, they have very extensive rules, but I looked for the same discussion, the same specific items for discussion that were included in our rules. And what I found was that really some of the phrases are even the same, and all the references to the various API reports and standards for Portland cement and pipe strength are all the same ones that are being used nationwide. So I just thought, for me anyway, that reassured me that they're perfectly willing to recommend passage, even if I'm not qualified to look at those pipe burst specifications and talk about how many PSI it should be. So in order to do that, let's see. So this is a selection. This next section is a selection of,
Commissioner Ballard, let me jump in and say one thing for the record on that. The Interstate Oil and Gas Compact, when they took a year to get onto their agenda, and they assembled a team of executives from the other states that from, I think it was 5 originally, other states, that did an analysis of all of our statutes and of all of our rules and compared it to what all the other states were doing, and then specifically to the states with similar types of production, and developed the recommendations based on that.
Thank you, Mr. Chairman. It really looks like it. They pared them down. Of course, Texas has offshore wells and horizontal, and they have more types. Their overall section is longer. But when you look up the specific things that we have, it reads very similar. So I guess what I'd like to do is if I have this on my screen, it runs on, the first section is on surface casing, and then there's a section on the intermediate casing and a section on defective casing. So if we want to, if we would just move the screen that we all share to the next section, which is the actual rule document for 110. I'll keep the Texas rules on, and we'll look at both screens together for just a little while. So just scroll down. You can see they got a lot of rules. And okay, so this is the first. Yeah, see as much as possible of it. This is the rule 110 on surface casing requirements. And if I share my screen, I have screen sharing not turned on. Let's see.
Okay. This is Angela Kane, Commissioner Ballard. Try it again.
Okay. Okay. Higher screen. So for some reason, let's see, I've got. Okay, I've got my rules. I'm sharing my screen, but I'm not seeing the rule on this side. I can call it up. Let's see.
Commissioner Ballard, this is Angela Kane. Wendy did show me where the Texas rules are in a PDF separately. If you'd like, I can just put them side by side on my screen if you
Okay.
deem to know how to go through them.
I'm perfectly willing to let you do that.
Okay, let's
So
try
yes,
this out.
if we could see this and then the Texas rules at the same time, it'd be perfect.
Okay, let me rearrange a little bit here. And, all right. Thank you for your patience while I rearrange screens here.
Yes, make it a little narrower maybe. I hope everybody can read. I hope everybody has a nice large screen. Okay, so this is perfect. So this is just starting with the first of those rules, surface casing requirements. And what I've more or less done is on the left-hand side where we have the actual language, I've found in the Texas rules really either the exact same language or a very similar type of approach. I found no conflicts. And when they get down to such as in Rule 110, Item 5, Number 8, where they start specifying references to API publications, the exact same ones are used in the AZOGCC/Texas rules. And I don't really plan to read through all of these points because I think it's look at a few, you'll see there's some changes and sometimes kind of an amazing similarity even in phrasing between the existing Texas rules and the proposed IOGC based Arizona rules. And in fact, let's see, surface casing, if you can just scroll them down, maybe to the second part of, yeah, this next one is on intermediate production casing. That's of course the next one you set after surface casing is set. And once again, you have specifications for the strength of the pipe, the quality of the cement job, and they're all the same. and actually, yeah, if you want to scroll on down to 112, which is a fairly short section on defective casing or cementing, it's almost just a policy statement, that about notifications that are required and the additional work that the commission may require, when something comes up with a problem, and it's very similar. So I know this is a lot of detail, but of all these three rules, I myself am really satisfied that the language got, passed over from the AZOGCC down to the revised Arizona rules, and I can recommend going along with them. The only change that I recommend, and I think we discussed it before, is in Texas and AZOGCC, there's no really specific depth to the surface casing. And there's some language like the operator has to determine if there's any, and they repeatedly use the word fresh water or drinkable water. And if there is a zone at, let's say, 100 feet, then you design your surface casing to, go below that and seal it off. But instead of relying on the determination of the operator, we really want to make sure that we are conservative on the amount of protection we give shallow aquifers. They're the ones that most likely people are actually using at this time. So the one change that I recommend to surface casing is that we use a 250-foot minimum. Most people do about that. In Texas, in very long, large wells, you can go much deeper. And then the other thing we have to avoid is we don't really want to say that we want them to define what usable water is, because in Arizona, it's all usable water. And so we want to make extra protection for the 250 feet without using some definition of what's good water and bad water. And then, of course, if something's significantly greater than 250 feet, that would be addressed with the intermediate casing. And that's all under the approval on an individual well by well basis of the commission. We know they're going to be in the shallow aquifer like the Coconino or something all the way down to 500 feet. We require the operator to either address it with a customized surface casing program greater than the 250 feet, and that would be also possible with the intermediate casing, which is going to go deeper anyway, and you just add some additional requirements there to make sure that the water zone is sealed off and safe. So we're taking a little bit of the discretion away from the operator, kind of simplifying things. It may, some unusual cases, it might actually be perfectly legitimate to just use 100 or 150 feet, but it's just a lot easier to have a robust minimum standard. So that's about the only thing I'd argue with all three of these.
Commissioners, comments, discussion?
This is Mike Conway. I think it sounds very good.
This is Shelley Cutts from the Attorney General's office. I just wanted to piggyback on Commissioner Ballard's comments a little bit. I agree about the differences between Texas and Arizona, because in Arizona, the law does designate all groundwater aquifers as drinking water aquifers. So I think Commissioner Ballard's point is well taken, to make sure the commission's rules comport with Arizona law that may differ from Texas. So thank you for that.
Thank you, Shelley.
This is Chairman Thorwald. I also agree. We've been working on this for a long time, years. This is 7 years we've been working on it. So hopefully we can get it defined this year and get it in. So I like it. Commissioner Fryerubin, what's your thoughts?
I like it.
Good. Anybody suggest any other changes, or is this appropriate? Again, we keep all of our definitions in the one area, so everything is defined through all of it.
Yeah, these statutes, I do not believe have a definition sections to
Well, we can just refer back to any definitions to that initial section on definitions. So, commissioners, do I have a motion to approve this? as it is or with any changes? What do you, if anybody has any?
Well, of
This
course,
is Commissioner
Chairman, this is-
Conway. I would so move.
Second? Does anybody have a second?
This is Commissioner Ballard. I'm willing to second it, and we should probably be specific as if we're referring to all three of these, casing related rules.
And this is for all three of the casing related rules. So is the first and the second for the all three?
I so second.
Okay. All in favor say aye.
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 Aye. All opposed say nay. Any abstentions? The motion carries. Let's move on to the next item.
Okay, well, we can go out of the dual screen. Yeah, thank you very much. That's always more complicated than I think it's going to be. So, yeah, we should be able to move back up to the displays that are. Nope, I guess we have to move down.
Okay, this is Angela Kane. Are we at the right topic now? So are we now moving to agenda item 4?
No, there's still a few attachments which
We're
refer to.
still
Okay.
on item 3, Angela.
Okay, I'm sorry. Let
And we
me,
also have to go back to definitions too and clearly finalize that.
There are some more issues here.
okay. See if I can get this back into the other one. That doesn't look like it. Okay.
So yeah, if we just move on to the next one, that's where we need to be. So this is 117. It's probably one of the more important topics. The previous rule was very brief, and so most of the language that they have provided for us is a very useful expansion of the responsibilities and the standards that would be required to basically do a hydraulic fracturing treatment in Arizona. But just to get to the more minor issue first, you can see that after just a slight renaming, definitely gets into some definitions. And the definition of artificial stimulation treatment, the definition of hydraulic fracturing. Yeah, this is actually, this is just I think some of the ones were already moved. This is just the really extended definition of artificial stimulation treatment. So I guess I would recommend that we take this term and probably utilize some of the language, a little bit of cleaning up that was done on the very first display that we showed, and put it into the definition section, which is 101. So we would take really all of section A, which gives a very extensive definition, and use some of that alternate language, but to put it into 101. The second is a much more substantive issue, and will require some examination by the commission. More or less the fundamental philosophy of the way this rule was written was that we could divide hydraulic fracturing jobs into very small ones and very big ones. And what they're suggesting is we really only modify the regulations and rules to cover the very big ones. In the past, the existing rules did not regulate essentially frac jobs. They certainly didn't regulate small ones versus big ones. So the idea really here would be to introduce regulations for large hydraulic fracturing jobs, and then really still for small jobs, still take a fairly passive role and not really aggressively regulate them. They require a lot of reporting, but they actually don't even require approval right now by us. So I guess I'm kind of recommending a change in tactic from what the AZOGCC suggested. I'd like to use all their really nice definitions of well, not the definitions, we're gonna move those, but the procedures and the reporting and the detailed requirements that they spelled out for high volume hydraulic fracturing treatments. And I would just apply it to all. So basically the only edit required is to eliminate this reference that they make to high volume and just include the remaining words. Hydraulic fracturing means that it would apply to any treatment. And of course, hydraulic fracturing is where you're pumping a treatment down the well and you're exceeding the fracture gradient of the rock. So you actually break the rock to make room for the sand and the fluids that you're pumping in. And if you don't exceed that fracturing pressure, it's not a hydraulic fracturing treatment. There are more less invasive forms of artificial stimulation, which should not be lumped together with frac jobs. Yeah, Mike Conway, myself, I'm sorry, Commissioner Conway, we looked at some numbers that I dug up from the file as to how big frac jobs really are in Arizona. And what we really find is that they haven't, none of the last ones that I know of were done in like 2015 time period. And they were really rather small. They were smaller than what would be considered in this rule a large frac job. So it actually wouldn't fall into the regulations that are proposed here. In fact, all the ones we could find are significantly smaller than the like 7,500 barrels of fluid. So I guess, I mean, it puts us in a bad position of saying that really we wouldn't have regulated any of the frac jobs that have ever taken place in Arizona, and we probably wouldn't regulate any of the ones that are likely to happen in Arizona, because unless we come across, well, a hydrothermal development might use large fracs, or some kind of undefined shale play that might be identified in the future might use large fracs. But for the things that are going on now, nothing would actually require the actions by this rule. So,
Commissioner Ballard, Chairman Thorwald, I agree. I think that this should cover any type of hydraulic fracturing, small, large, and everything in between. Commissioner Conway, what do you think?
I wholeheartedly agree with that.
Commissioner Firerobbin, what do you think?
Agree.
I think we're all in agreement with that. My question would be the fluids, what is used in the hydraulic fracturing itself, whether it be nitrogen or whatever it might be. Obviously, nitrogen is a non-pollutant. So do we want to take into consideration, I mean, nitrogen will not pollute water, it will not pollute the ground, not pollute anything, versus, say, something else? Do we want to have any kind of definitions or anything outlining that type of thing? Or how do we, I know DEQ looks at the content of the frac fluids. Do we want to do anything in that area?
well, Mr. Chairman, I'll just say this, Commissioner Ballard, that that gets us into a lot of technical details and possible components. I think there's quite a few. What this rule does quite well is require that a very specific plan be proposed for approval, and that would have to include everything that they're going to use. And then there's also a lot of procedural and follow-up reporting done on how the job actually went. So I guess I would say there's already a lot of detail. Anything that was proposed would have to be described in detail and approved by the commission. And I would think at that time would be the time to decide if what they're going to use is standard, and maybe with some advice if it looks like it's something non-standard.
I think that's highly appropriate myself, but also many of these frac fluids are proprietary to the different companies. How do we deal with that?
I think that situation has evolved over the years, and there is a requirement that if you scroll down toward the end, there is a requirement for complete documentation of the fluids that were used.
I'm thinking the public confidentiality with respect to those fluids, since they are proprietary between companies for the performance.
I know that has been an issue in the past. I'm under the impression that they have to report them here.
I know, but I meant from us making that, providing that to the public.
This is Shelley from the Attorney General's office. If there is information that's given to a public body or to the government, that is a trade secret or is otherwise subject to a company's claim that it's a trade secret and should be kept confidential, then that would be the type of document that the government could exempt from disclosure under the public records law. So what I would say is that should you obtain information like this from a company that a company deems as proprietary, it would be good for the company to let you know that, so it could be kept, filed a little bit separately. And then, of course, if there is ever a public records request for that document, then the Attorney General's office can assist the commission in determining whether that document is exempt from disclosure.
Thank you, Shelley. Commissioners, it seems like we should add something in here to that respect, to that effect.
This is Shelley Cutts from the AG's office. There are statutes in Arizona that address this, so I'm not sure that you would need to address it separately in rulemaking. So I'm not exactly sure what it is you're looking to address in the rule, but definitely let Taylor and I know, and we could see if we can help you craft some language if you need assistance.
Shelley, what I was thinking of, Chairman Thorold, is that we at least refer to those statutes and say, for proprietary information that is your trade secrets, refer to statutes so-and-so.
Yeah, I would have to research, or Taylor would have to research those statutes, but you could say in the rule that proprietary information shall be deemed confidential, is authorized under Arizona law or is authorized by Arizona law. And I think that would probably cover it in terms of your rule. And then if specific statutes need to be researched, that would be good. Also, statutes come and go, numbers change, stuff like that. So sometimes it's better not to refer back to any one particular thing, but just to identify that that trade secrets will be kept confidential as authorized by Arizona law.
Yeah, thank you. Commissioners, what do you think of that?
Well, this is Commissioner Ballard. I would like you to glance as to where we might put some language like that, all the way to the very last section E under number 8, I believe, all the way to the bottom of this this rule. So this is what the rule would require. They would be required to reveal all the fluids and chemicals that were used and actually put them on a public website, which is, I guess, standard operating procedure. And I am not sure if they are allowed any exceptions, like using the brand name or something for an additive that everybody knows what it is, but don't have the specific proprietary formula or not. So if there was going to be some exception in what they have to, how they tell us, if it needs to be being held confidential, I suppose we'd have to modify this reporting requirement.
I would be fine with that. Commissioners, what are your thoughts?
This is Mike Conway. I think that works just perfectly well.
Commissioner Farrell.
I agree.
Go ahead, Commissioner Ballard.
Oh, I was just going to say that would be my idea, is that this would be the place to put in some kind of a comment that trade secrets could be supplied confidentiality to the commission.
Okay. Any other discussion on this?
No, that was really, you can see as you scroll through, it's really this change in philosophy for eliminating the high volume, and everything reads fine. It just covers all situations instead of just high volume. And then
Commissioner Ballard, would you make the changes in this that we've discussed?
yes, I'll take a stab at that comment about proprietary formulas or something, and I may want some little help from the AG's office as to how I should phrase that, or review how I phrase it.
Question for the AG's office. Can we vote on approving this as modified, or should we wait till Commissioner Ballard has made the changes?
This is Taylor Parmenter from the AG's office. I would suggest waiting, since you would have to vote again on any changes that Commissioner Ballard proposes.
Okay. Commissioner Ballard, do you think you could have this ready for our next commission meeting?
Oh, certainly. And I'll even take a look at the standard. I guess this is where this came from, of course, the standard AZOGCC regulations. But I'll just confirm my own curiosity as to what Texas or New Mexico has in there for this.
Okay, thank you. If there's no more discussions on this one, let's move to the next item.
Well, I believe this is the last rule to be modified. Just to be complete, this was another rewording, basically, of the rule. Like you say, these efforts go back many years. So this is also something we have available. It follows the approach that you kept the definitions in with the rule, and then goes on to include the other items that are in the rule. So I think this came from your files, Mr. Chairman. If you know anything more specifically about it.
No, it does bring up a good point, though. For instance, in the helium fields, most of the helium in the state has no well, none of it has any hydrocarbons, and with inert gases, but ones that the helium that comes from the CO2 fields certainly has CO2 in it. Do we want to do anything that with regard to defining what those differences are between, in other words, in other states where hydrocarbons come up, you have to do certain kinds of rulemaking, or have certain, they come under certain rules. And if they don't have hydrocarbons come up with them, there's certain types of rules. They fall under different categories. I'm not making myself very clear, am I?
Mr. Chairman, this is Commissioner Rowley. I think I understand what you mean. And of course, actually, our rules, in general, we do cover, oil as well as gas. There's instances where they're separately referred to. As far as artificial stimulation goes, unless you really get down into the details, I'm not sure there's big distinction to be made. Of course, in actuality, in Arizona, there were some hydraulic fracturing for oil wells, but that was all up in the northeast corner of the state a long time ago. And when, of course, more modern wells are fractured, it's usually for oil. There's gas objectives, but it's often mixed with water and hydrocarbon gases. And I'm not, except for some surface equipment to deal with those different fluids, I'm not sure the real process that we're talking about of regulating a company planning and executing and reporting hydraulic fracturing would be different.
Okay. I personally, as Chairman Thorold, like what we've worked on in the previous piece, and I think we could just drop this off. The other version is much more thorough. That's my thoughts. Commissioners, what do you think?
This is Mike County. I'm okay with that.
Commissioner-
Robin, I agree.
Good. Good. Then we'll just go with the first version there to make the changes. What do we have left? The definitions?
Well, I think I have a couple of recommend. We'll end up having to approve 117, later when the changes, including removing the definitions, are finished, and of course changing it from high volume to all volume of fracture treatments. So we'll have to review and approve that, and we will have to review and approve 101, which we can scroll up to and look at. But the main changes to 101 would just be to add a couple of these definitions that we need to add, particularly artificial stimulation. And so I won't have that specific language for you. Yeah, go all the way up to 101. That's 110. It's quite a ways up by now. So yeah, this definitions.
When is our next public meeting? It's in November, isn't it?
Should be.
I think is it the 10th?
No, I would think it'd be more like the 21st. I don't have it notated on my calendar though.
I don't either.
Horrible. This is Angela Kane. I'm looking at the calendar, and the next meeting that I have marked is November 21st at 10 a.m.
Then what I would recommend is that we have one other meeting specifically to address these two prior to that. So to our regular meeting, so that we can get these out to our stakeholders and get their comments and on it. Commissioners, that would be a very short meeting because we would only be addressing those two items. Would that work for you?
What date, Fire Robin?
Commissioner Ballard, when do you think, without pushing you too hard, you're doing when do you think that would be available?
I mean, a week's fine for me, but we would have to, of course, go through the standard period of notification and agenda, and I can't quite remember what that standard is. And if you have to be 10 days.
24 hours.
Oh, 24 hours. Well, let's not do it next week because that's Halloween. Let's either do it on the 30th or something like the following week in November. I could actually do it on the 30th.
I could also do it on the 30th. Commissioners, how does that day look for you?
This is Mike County. I can do it on the 30th.
Commissioner Fireoven?
30th gets complicated for me. I getting into some medical procedures.
What does the 29th look like?
29th would work for me.
Yeah, it would work for me if we did it in the morning.
We
I
go
can do
back
the
to normal
29th in the
time.
morning.
I'm sorry?
This is Mike County. I could do the 29th in the morning.
Okay. How about Commissioner Ballard, can you do the 29th in the morning?
Yes, I just penciled in 10 o'clock. Does that sound good?
10 o'clock would be good for me. Does that work for staff?
Chairman Thorwald, that's what I was going to say. The 29th, it's really heading up against some other things that we have going, and for one thing, Wendy is out. So
I I'm thinking this won't take us 30 minutes at the most.
Okay.
Would that still be a position?
We can make it work.
Say, we set it for 10 to 10:30. That gives us a clear, defined amount of time. That work for everybody?
Yes.
Good. Is there anything else that we need to go over? Let me go back. I know we've already done the call to the public. We have quite a number of people on the line that have heard what we've been talking about. I would like to ask anybody that's online and the public to see if anybody would like to weigh in on what we've talked about and get their input right now. Would anybody in the public like to address the commission on anything? Hearing none. It is now to figure out the time here. It is now 2:35 on October 24th, and this meeting of the Arizona Oil and Gas Conservation Commission working session is concluded. Thank you all.
Thank you.
Thank you.
Good weekend.
Thank you, everyone. Appreciate it.